Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we got some big news out of California, and for once, it's good news out of California. Yeah, for those of you who've been geeking out on the Twitter sphere today and all that, you may have already heard about this huge win in California. It has to do with California's handgun roster. And this is really the tip of the iceberg. The dominoes are beginning to start to fall, as we talked about in this video right here. So today we're going to celebrate what I believe is the first in a series of big victories coming our way. Let's spend a few minutes and talk about how a huge win in California shows the dominoes are starting to fall on gun control. Okay, so the case we're talking about today is a case that we talked about in this video right here. It's one of 5 cases that we talked about. This is the case of Boland v. Bonta. Now, this is a challenge to California's handgun roster, and I gotta tell you that for as crazy of gun laws as we have here in the state of Washington, I was not familiar with California's handgun roster until I started doing some research for this video. What tipped this off? Well, as usual, Costas Moros down there, there's his Twitter handle. He was one of the attorneys involved in this suit. Congratulations to him and his entire law firm. This is an amazing victory. I did get an opportunity to take a look at some of the material, including the ruling from the court, which now issues, this is important, an injunction against the enforcement of this law. What does California's handgun roster do? Well, apparently, the state of California knows better than the rest of you as to what kind of guns you should be using for self-defense. And in fact, unless it has certain types of safety features, it's not allowed to be on California's handgun roster. And of course, if it's not on California's handgun roster, well, then you can't buy it. Now, this comes from California's Unsafe Handgun Act. Okay, so the 3 challenges here in Boland were 3 pieces of technology which the state of California said had to be implemented on any firearm that was going to be sold in the state. The first one is a loaded chamber indicator, okay? The second one is a magazine disconnect mechanism, which makes the firearm inoperable if a magazine's not fully inserted. And then the third and final one is micro-stamping capability. Now, while I think that that's a really neat idea on behalf of California, currently, there is not a single firearm anywhere on the planet that complies with all 3 of those requirements. As a matter of fact, there's not a single firearm on the planet right now that can comply with the micro-stamping technology. The technology may be there to some degree, but the ability to implement it across the industry, we are years and years off from that. So essentially what California did is they said, hey, listen, unless the firearm has any one of these components, you can't sell it in the state of California. What does that mean for Californians? Well, it means that most firearms that you can buy are at least 16-year-old models, because nothing has been allowed to be added to that, with the exception of 16 firearms. 16 firearms have been added to this roster since its inception in 1999. However, when you really want to geek out on it, all 832 firearms currently on California's handgun roster, none of them comply with the statutory requirements. So the question is, can a state pass all of these ridiculous laws, none of which has anything to do really with saving lives, and thus restrict the ability of that state's residents to buy a large array of firearms because the state deems them too dangerous to own? The answer from the United States District Court, Central California Southern Division is no, you cannot. Not only can you not do that, that's a complete infringement on one's Second Amendment rights, but the court has ordered, and this is important, an injunction, which means it will stop the state of California from enforcing this law. Now, this inevitably is going to get Gavin Newsom and Rob Bonta to immediately appeal to the Ninth Circuit. We'll talk about that in a minute. But this is big news for everybody in the Ninth Circuit, huge news for those in California. Now, what got the court to this result was the Bruin holding, because the court very correctly stated, hey, listen, under this new one-part test, if the activity is covered by the text of the Second Amendment, it is per se unconstitutional, and it will be the government's burden to come up with some type of historical analog that shows that we as a country have readily accepted this type of regulation. Now, the government, the state of California here, of course, threw everything at the wall hoping something to stick. And they really came up with 3 historical analogs. Number 1, proving laws. Ever heard of proving laws? Of course you haven't. They're that old. approving laws were basically safety inspections of muzzles and barrels on firearms to ensure that they were safe for firing. The court said, nice try, but no, that's not a historical analog. The second one had to do with gunpowder storage. Now, I'm not sure how they wanted to extrapolate gunpowder storage to laws that basically prohibited any modern firearm from being purchased. The court was not particularly persuaded by it as well. The third one, and perhaps this is the most offensive, is that they believed that the laws that require serial numbers on firearms were tantamount to what the state of California was mandating of its citizens here. And obviously, the court was not persuaded by that either. Now, of course, California Attorney General Rob Bonta did not take the news very well of the ass whooping that they just took in court. The Attorney General was quoted as saying, "The fact of the matter is California's gun safety laws save lives, and California's Unsafe Handgun Act is no exception. We will continue to lead efforts to advance and defend California's gun safety laws. As we move forward to determine next steps in this case, Californians should know that this injunction has not gone into effect and that California's important gun safety requirements related to the Unsafe Handgun Act remain in effect." And while that may be the case, Mr. Attorney General, the court has given 14 days for you to file your appeal before that injunction does in fact go into effect. Now, to give you an idea of how the court was far less than persuaded by some of California's arguments, let's take a look at what the court issued as far as a ruling today. The first thing I want all of you in California to be aware of is how positive the news is when you win an injunction. Because the rule of law, to put it in simple terms, is that one, you must show irreparable harm. And number two, you must show that you have a likelihood of prevailing on the merits. That is, you are likely to win this argument on the merits. Now, the court said that the test was, one, that they are likely to succeed on the merits. Two, that they are likely to suffer irreparable harm in the absence of preliminary relief. Three, that the balance of equities tips in their favor. And four, that the public interest favors an injunction. And the positive news, and this is what begins to start tipping the dominoes, is the court believed that to be exactly the case. The court basically summarized this law as follows. The challenged UHA provisions unquestionably infringe on the right to keep and bear arms. Plaintiffs seek to purchase state-of-the-art handguns for self-defense. The UHA prevents this. And this argument about, well, you know, they can buy some guns, so what's the big deal? And that actually was one of California's arguments, was not persuasive to the court when they commented, indeed, the Constitution protects much more than the bare right to keep and bear any outdated firearm for self-defense. The Second Amendment also protects attendant rights that make the underlying right to keep and bear arms meaningful. And I want all of you to make note of that when it comes to the magazine ban that we are likely to get a ruling on any minute as well. And the fact that people can just go ahead and buy other guns, again, was not particularly dispositive with the court when they commented, "We would never say the police may seize and keep printing presses so long as newspapers may replace them, or that they may seize and keep synagogues so long as worshipers may pray elsewhere." So yes, California, you have had a big, big momentous day. Now, this injunction is going to go in place in 2 weeks, but we know that the state of California is going to stampede to the Ninth Circuit as fast as possible and appeal this injunction and appeal this ruling. However, this is where things are going to get real interesting, because although we know that the Ninth Circuit wants to, in the worst way, undo this ruling and back the state of California out of it and make sure that these laws remain in effect, the United States Supreme Court, through the Bruin opinion, has significantly, and I do mean significantly, boxed in the Ninth Circuit as well as every other circuit court. That great escape hatch that these courts use, that balancing test, societal needs against the individual's rights, that's been weld shut already by the Bruin opinion. And so if the Ninth Circuit properly applies the law, there is only one decision, and that is to affirm the trial court. So the bottom line here, California, is that this is a huge day. It is a momentous day. It is a big victory. But most importantly, it is the first in what I believe is going to be a long string of victories. I think this is the first domino of a long series of dominoes that are about to fall. all advancing what otherwise are inalienable rights. Listen, you may have more questions about this case or anything else related to what's left of our Second Amendment rights. If you do, you know how to contact Washington Gun Law, and if you don't, hey, all of that information is in the description box down below. In the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.